As far as my personal planning, my husband and I have a trust, and that trust is a legal contract that states what we want to happen when we're no longer here or if we become disabled. We're a married couple, we're able to utilize one trust. If I pass away, everything is there for him. If he passes away, everything is there for me. When we're both gone, whatever's left would be divided equally amongst our children. Along with the trust, we have our healthcare directives, which would be our healthcare powers of attorney, we each have one, our living will, we each have one, and our HIPAA authorization forms. Your healthcare power of attorney is the document that states who should take over and make medical decisions for you if you're no longer able. We've named each other, then we've named our daughter Blair, followed by our son Jake, followed by our daughter Jenny. This document will allow them to make necessary healthcare decisions if we can't speak for ourselves. The next document is a living will. That's the document that states that we don't wish to be kept alive by extraordinary means if there is no hope. And our healthcare agent would be involved in that decision. Those documents changed in 2008. Prior to 2008, it was the doctor alone that would make that end-of-life call. Now the doctor working with our healthcare agent decides that. There's also the HIPAA authorization, which was brought out in 2008 to protect our healthcare information. We have both signed these permission slips that will allow any of our family members to make these decisions, to pick up our prescription medicines, to look at our medical records, and to release our medical records to entities such as our insurance companies. The other document that Mark and I have is a durable power of attorney. This is the document that if we can no longer speak for ourselves, it would enable the other to take distributions from retirement accounts. It would enable the other spouse to deal with benefits that we may be entitled to. If there's a problem with the Social Security check, if there's problems with our health insurance, and maybe the health insurance company won't authorize some type of treatment that the doctor recommends, such as an MRI, what would give my husband the right to speak on my behalf about getting that financial benefit made? It is the durable power of attorney. There's also something called a pour-over will. That's a document when we're using the trust, and the trust is that contract that has all of our assets integrated in it that will keep our family from going through probate. The pour-over will is in case we forget an asset, which I hope never happens. We give our clients laminated cards with their trust name on it so that after our office puts all of their assets into the trust, if they're out there in the world on their own and they buy a new house or they open up a new account, they just use the laminated card to access the trust and to integrate that asset into their documents. Mark and I also have disability insurance. We're still working. If something happens to one of us, we want to be able to make up that income. Furthermore, we have long-term care insurance. If we need to go into a nursing facility, we don't want our hard-earned assets lost to end-of-life care. It can be $6,000 to $10,000 right now, and in the years to come, it'll be even greater. So we're always trying to hedge against loss. And with long-term care insurance, that is a feasible way to do that. Clients can take money from their IRA or other places that they wouldn't think of, like life insurance, when they no longer need it, to fund a long-term care insurance policy. So that's what my family has done. Let's see what we can do to help your family.